Okay, so recording has started. Juet will take part in a short fireside chat with our partner, Dr. Siefert, where she will share her insights into her arbitration experience in Singapore. And after their little Q&A session, you, our Moody's and coaches, will have the opportunity to ask non-case related or organizational questions to both Juet and also to us from Bodenheimer. So in total, the session should last approximately 1 hour. And if there are no further questions at this point, I give the floor to Leah.
Thank you, Anita. Just also a small reminder that if you have any questions regarding the pre-moot itself, please rest assured we can answer all of them after our session is over. But of course, as Anita already mentioned, we're always reachable via email. But now it is my pleasure to introduce Dr. Christoph Siefert, who's a partner with Bodenheimer. He's a German and New York qualified attorney who has been dedicated to training teams for the BODENHEIMER for many years. So, Dr. Siefert, the floor is yours. Thank you.
Okay, thank you very much, Leah. Thank you very much, Anita. Good morning, good afternoon, good evening, wherever you are. It's truly a pleasure to welcome you to the opening ceremony of our pre-moot. And this pre-moot, already the sixth one, our Bodenheimer Pre-Moot, is very special. We have 30 teams from 20 countries from all 5 continents. This is very amazing, and thank you to all of you for being available for this hard work over the next 2 weeks. And this is very much like our firm. We're truly international, once you have heard that. Our people, attorneys, cover 6 jurisdictions on 4 continents. And this is what the moot court, and particularly the Bodenheimer Pre-Moot, is about. We want to show you how real life is. And to give you an example, I won't go into the case, but about 3 years ago, I had a case which was not about orchids, but about lupins. And you can make vanilla ice out of lupins. I wasn't able to know that. So this year's case is truly what real life is about. Again, we won't discuss this case, but the fact that the ZIAC rules apply here makes it open that, or is it, it's obvious that we should have a guest speaker from Singapore, and we are very honored and proud to have a very renowned guest speaker, Juet Min Fu from Singapore. And I have the pleasure of discussing a few issues with her, but let me first introduce her. So if I may say Min, she graduated with first-class honors from the National University of Singapore in 2006. And she was not doing the BODENHEIMER, but the Philip C. Jessup International Law Moot Court Competition at that time in Washington, D.C. She joined the firm. She is currently a director of dispute resolution with Drew and Napier in 2008. After that, she was a law clerk at one of the justices of the Supreme Court of Singapore. That's very interesting. And was appointed to the Supreme Court's Young Amicus Curiae scheme in 2010-2011. And Min, you will tell us a little bit more about what you're doing. But first, I think I need to mention that you do very much what we do too. You are involved in bilingual arbitrations. In your case, it's English and Mandarin, and some other questions. And we talked before, and it's always important that you do something, well, pro bono and in addition to the law. And I was very excited to learn that you are involved in an access to justice project in Laos. That is very good. And in your spare time, if there is some spare time, you enjoy not only your 2 children, but you enjoy dancing with the Singapore's most famous dance schools. Let's see whether there's something we can learn about that. But first, let me turn to your professional background. And can you please tell us a little bit more how you came into international arbitration? What led you to focus on international arbitration?
Thank you very much, Christoph. Very good morning, afternoon, evening to everyone as well. As Christoph has very kindly mentioned, I have been with this same firm since the beginning of my practice career. I do both litigation and arbitration in my practice, both as counsel and in arbitration as arbitrator as well. While you all would be familiar by now with the SIAC rules, and maybe some of you have read a bit about the SIAC and how it came about. SIAC was set up around 1991, quite some time ago, but arbitration actually really flourished in Singapore only, I suppose luckily, around the time that I started practice. So around 2007 to 2008 was when arbitration truly flourished in Singapore. And the reason for that is a very interesting and simple one. It is because the Maxwell Chambers was built. So if you have heard about the Maxwell Chambers, it is a dedicated space for arbitration hearings. So arbitrators love coming to Maxwell Chambers. It is a very nice arbitration venue. Now it has doubled. It's now arbitration Maxwell Chambers as well as Maxwell Chambers Suites. So around that time was really the time when arbitration flourished. When I was in school, arbitration as a subject was not really something that people did. There were very few courses on arbitration and didn't really do arbitration in school. There was BODENHEIMER, but arbitration was not really offered as a subject. About 5 years into practice, and in the beginning, I did a mix of arbitration and litigation, quite a balanced mix, I would say. But about 5 years into practice, I started focusing on international arbitration. Ironically, because of a very disappointing court judgment that I got. Because of that, I actually asked my mentor, Kavinder Bull, who's current CEO of my firm, to let me do a bit more arbitration. I always say, because of this, I always say that everything happens for a reason. So because of that, I started getting involved in many of the arbitral institutions, committees. It started with Young SIAC, and then I was doing work for Young MCIA, the Mumbai Center for International Arbitration, because we do quite a lot of India work. And then after that, I started doing things with ICC and currently with Delos as well. So I would say that that's how I sort of stumbled into international arbitration. The interesting thing about international arbitration, interesting and I would say interesting as well as lacking sometimes. After many years of doing international arbitration, I realized that my practice was all about contracts. Because if you don't do court litigation as much sometimes, you start to not do too many of the cases involving tort, on that kind of cases. Almost all your cases are contract-based, which is interesting as well as sometimes I feel that to be lacking. And so anyway, I do both nowadays. But as Christoph mentioned earlier, you learn a lot of interesting things in international arbitration. One of the more interesting areas that I really enjoy is sports arbitration. And in sports arbitration, dealing more with the commercial side of it, it's a bit different from the kind that you do in CAS in Switzerland. It's more to do with sponsorship, commercialization of media rights. And I learned a lot about things like how do you download the link from satellites, how does a live stream go out for each of these major sports competitions. And so international arbitration has always been something truly enriching for me. You learn a lot of things from many industries and many jurisdictions, and meet people from all walks of life. So that's a bit about my background in terms of what I do on a daily basis in my role here at Drew & Napier.
And that's very interesting. That's probably the first lesson we learn. It doesn't fly to you, but you have to get it. You have to approach a law firm who does international arbitration, and the BODENHEIMER is probably really the first step to do into that. So very good. And as you said, you did the Jesuit Moot Court, and that's right. At that time, there weren't much lectures, but now that's getting better. There are more lectures on that. Particularly in Singapore, and that may be interesting to us. Singapore is considered among the most preferred arbitration seats worldwide. You mentioned there is a center which has good probability. The reachability is also important. But from your perspective, why is Singapore becoming such an international hub for arbitration? Is it that Singapore law is so good? Is it that mere logistics, or what do you see as a major reason for the success of Singapore?
Hmm. I think it's a combination of a few factors. One of them surely is the legislative framework around arbitration, international arbitration in Singapore, as well as a certain judicial attitude of the courts towards arbitration and arbitral awards. I think that's something that is important for most users of arbitration. Most people see Singapore as this neutral place that truly upholds the value and the nature of arbitration. So apart from being a party to the New York Convention, which many countries are, our International Arbitration Act incorporates the ancestral model law on arbitration. And so in that sense, sort of aligns Singapore's arbitration framework with many other countries in the world. So globally, there is a certain set of accepted rules that is quite international in nature, I would say, and quite standardized across the board, whether common law or civil law, whether in common law or civil law jurisdictions. I think you will not find yourself in completely unfamiliar ground when you are dealing with Singapore as a seat. That's one. There's also the policy of minimal curial intervention in Singapore. So the Singapore courts have this attitude where they, as far as possible, they will not interfere with the substance of an arbitration award unless there are severe breaches of natural justice. So very, very narrow grounds where you can attack an arbitral award. So there's a lot of finality and certainty around arbitration awards. That is something that the courts are very protective about. The other reason is, of course, also that Singapore as a country has a very low corruption rates and very strong rule of law. And I think many users of arbitration see that as a true value of Singapore as a seat and as a place of arbitration. There's a stable legal and political environment. By and large, I think it's very, very stable. So you know that if you choose SIAC or you choose Singapore as a seat and the dispute happens 10 years later, you are more likely than not to be dealing with a similar environment and a similar arbitration environment. You don't expect that it will be drastically different. So I think that's something that is very important in high value or sensitive cross-border disputes. And that makes Singapore, I think, one of the leading arbitral seats or venues of arbitration worldwide. The other reason I would say is there is a very strong network of arbitral institutions in Singapore. So in Singapore, it's not just about the SIAC. SIAC is obviously a leading arbitral institution that sort of anchors Singapore's position as an arbitration hub. But Singapore also is host to many other regional offices of the arbitration in many other arbitral institutions. So, like, for example, ICC has a regional office in Singapore. The PCA, the Permanent Court of Arbitration, has an office in Singapore. And very soon, ICSID is going to have an office in Singapore. And I think most recently, I also heard that the Shanghai International Arbitration Center is going to set up an office in Singapore. And that will be the first Chinese institution that's going to come into the Singapore arbitral landscape, so to speak. So in that sense, many of my peers, my friends in international arbitration, we do a lot of arbitral events for all the institutions. So it's always not just SIAC. We do it for ICC, we do it for, if sometimes even LCIA, during Convention Week, we have LCIA events, because we see it more as an entire community of arbitration practitioners. So it's very diverse in that sense. It's regional as well as international. there's one interesting thing about arbitration in Singapore, which probably is a bit different than in Germany. When you do arbitration in Singapore, you are almost certainly doing an international arbitration. There are very few domestic arbitrations in Singapore. It almost doesn't ever happen. In my entire life in Drew, I have ever had one domestic arbitration case. Singapore is a very small country, and so almost every single case that you do in arbitration would be international in nature. That's something quite interesting for us because it's a small country. I think for many big economies like Germany, you have many more domestic arbitrations. While in Singapore, the one of the things that is interesting is that most domestic cases will go to court. Of course, we will come to that later. The 2025 rules of the SIAC rules changed that quite dramatically with the introduction of the streamlined procedure. And so that is expected to change the dynamic of how people choose their dispute resolution forum moving forward. So I think those are the few things I would say are different, or rather stand out in terms of Singapore as an arbitration hub. There are also some things that are, I suppose, in a way, people always compare Singapore to Hong Kong, to London. There are some rules that are different. For example, if you compare Singapore to Hong Kong, in Singapore, you can, for example, appeal against a negative jurisdictional ruling, whereas in Hong Kong, you can only appeal against a positive jurisdictional ruling. There are these kind of differences. If you compare Singapore to London, in London, because London is not a model law, it's not a model law country, it allows a bit more court intervention, and the court you can actually appeal to the court on issues of law, while in Singapore, that's not allowed. In the international arbitrations, you're not allowed to appeal to the court, even if you think that a tribunal has applied the law wrongly. So there are those kind of differences, but by and large, when you compare all the arbitration venues and hubs, by and large, you get rules that are pretty similar, I would say. So I think in Singapore, truly, one of the differentiating factors is really the infrastructure and the entire community around international arbitration that sort of makes it stand out.
Yeah, these are many reasons, and certainly it's a great place. But you mentioned England. As I understand, Singapore is a common law country, so that influences not only litigation but also arbitration. But how do you see the common law, civil law divide, also when it comes to the SIAC rules? Do you still consider yourself more a common law jurisdiction, or do you try to close the gap between the two systems?
And this is something that became a very huge topic when I was in law school. So I think comparative law studies started in the National University of Singapore around the time that I was studying there. Arbitration, of course, is truly a civil law creature. It's a creation of civil law. A lot of things in arbitration are quite different from common law litigation. Until today, you will still see many common law practitioners going to an arbitration and treating an arbitration like litigation, which, if you are a true blue arbitration practitioner, you will say no to that. I mean, that's not something that is welcome in arbitration. I do think that somehow in recent years, more and more arbitrations have adopted many more common law features. I'm not sure I say that's a good thing. I'm not sure I think that's a good thing, because in the beginning when I started arbitration practice, I found that parties were able to agree on most things. Most procedural things, there was no fight. Everybody sort of wanted to get to the gist of the merits of the case and argue the case. But somehow, or maybe at least in my part of the world, it's become a bit more antagonistic. But by and large, I would imagine that the rules are actually quite similar. If I have to choose an arbitrator for my case, I don't really differentiate between the civil law arbitrators and the common law arbitrators. I look out more for whether I think they are going to look at a matter fairly, whether they will be able to manage the procedure well, and features like that. So the common law, civil law divide, I think, is narrowing. I also took a look at the SIAC panel of arbitrators, and I realized that actually common law and civil law arbitrators is about 50-50, which is about 50-50. Of course, I cannot differentiate, I cannot be more precise than that. But, oftentimes, even when I have an English law governed arbitration, it doesn't really stop me from choosing a civil law arbitrator for my matter. And I think that indicates to me that the divide is blurring, is really blurring. But and also I think in civil law traditions, there are a lot of good things about civil law traditions in arbitration that I wish sometimes that the courts would adopt. In arbitration, the process is much more truncated. You realize that many complex things can be dealt with in a much more efficient manner in arbitration. And I think that truly comes more from the civil law tradition than the common law tradition. Because the common in courts nowadays, even in Singapore, we have very long hearings. Whereas in arbitration, you seldom have any hearings that is more than usual commercial cases, no more than 2 weeks. We seldom have anything more than 2 weeks. Usually it'll be done in a week, sometimes even in a couple of days. So I don't really see that, I don't really see a real divide. The other thing that has happened in Singapore over the past 10 years or so is the development of the Singapore International Commercial Court. And the Singapore International Commercial Court, SIECC for short, is introduced a bit of an in-between litigation and arbitration. So it adopts certain things from certain features of litigation and adopts certain parts of arbitration to try and give parties a different another option. And the interesting thing about SICC is that it hears a lot of the arbitration-related litigation nowadays. And the composition of the SICC judges is very international. So we have former French judges, we have former Japanese judges sitting as judges on the International Commercial Court. And that really is as something to cater to the fact that many of these arbitrations that could come from civil law backgrounds, could be that the governing law is a civil law, could be French law, could be German law, that those cases may come before the Singapore courts for setting aside or for enforcement. And in those cases, you will have international judges from a civil law background looking at those cases. And when you couple that with the fact that Singapore adopts this minimal curial intervention, they try not to touch the substance of the case. So even if your case is governed by, let's say your case is governed by German law, but is Singapore seated, when it goes before the Singapore International Commercial Court, with the international judges, as well as the fact that they try not to meddle with the substance of the case and deal only with whether there was a due process and whether the tribunals kept within a certain scope of their mandate, you realize that whether or not the case is civil law backed or common law backed will not really have an impact when you choose Singapore as the seat. I think that's how we have positioned ourselves, and I think that's how the rules have been created to create that neutrality.
That's very interesting, and that's a development we also see in Germany. Arbitration has started as an alternative to litigation, particularly in the United States, because litigation took too long, was too burdensome, and so on. And now the empire strikes back. And we have also commercial courts in Germany right now, which try to be in a competition to arbitration. So that's quite interesting. And it's also interesting that you think that arbitration came more from the civil law tradition. We always thought it's more the common law tradition, but that's something almost philosophical. Let's turn a little bit to the mooties, to the moot court here. The phase of written submissions has ended. So we're going to have the oral hearing the next 2 weeks. We're very excited to hear many of the students here in our test sessions. oral advocacy is something which we connect to common law. And we always praise English barristers of being so perfect in presenting the case. And I assume that is, and since you do litigation to arbitration, something which is very important. So what do you think is important to make someone a strong oral advocate? What should she or he do in order to be successful in this regard?
Arbitration has always been, when you compare arbitration and litigation, usually people get much more advocacy practice, like oral advocacy practice in litigation rather than arbitration. The rise of arbitration is the reason why written advocacy has become so important in our practice, much more than when I first started. But I think coming back to oral advocacy, I think there are three things that I feel are very important. The first is the clarity of arguments. I think how you are able to make everything sound simple and direct is truly the essence, I think, of a very good advocacy. The ability to distill complex facts and law, complex, factual scenarios and matrix into a clear and coherent narrative, a story that can assist a tribunal in coming to the decision, hopefully in your favor. I think that is the first most important thing about oral advocacy, is really trying to make things as simple as possible. And nowadays, what I do is I try to argue my case with my kids, to my children. I try to make my children understand what I'm trying to say, and if they can understand, I think I probably have made it as simple as possible. So that's one thing. Clarity of arguments, I think, is the most important feature of good oral advocacy. The second thing is I would call it either a responsiveness to tribunal, or to say the ability to read your tribunal. Whether you are in court or whether you are in arbitration, you have to read the tribunal. Always, because I think often when you prepare for oral advocacy, most of us have a certain rough script. It may not be word for word, but you have a general idea, you have a rough idea where your arguments are going. But the truth in advocacy is that you have to respond to what the tribunal wants. You have to listen carefully to the tribunal to answer the question that they want answered, and not what you want to tell them. I mean, of course, you should tell them what you want to tell them, but it's more important to answer the question that the tribunal wants you to answer. And that sometimes may require you to depart, to move away from what you have prepared in your for oral submissions. You may have to do that. Of course, I think one of the real skills of oral advocacy is then trying to pull the tribunal back to where you want them to be, or where you want them to go. But I think it is very important to respond to the tribunal, to not leave questions hanging, to not make any member of the tribunal feel that their question has not been addressed, or their concerns have not been taken into importance. I think that's quite an important feature as well. The other thing that I think is quite important in arbitration as well, as you deal with arbitrators as well as, I suppose, judges in the BODENHEIMER who will come from all sorts of backgrounds, is also a sensitivity, I think, a sensitivity to different cultures, to different legal traditions. Try and understand where they are coming from, why they are asking a certain question, because sometimes you may dismiss something as, the tribunal member may not have read the question carefully and things like that. But it could be because there are certain assumptions that are different in different legal traditions. And so arbitral tribunals come from different backgrounds. Opposing counsel in international arbitration come from different backgrounds. And the legal backgrounds can be very diverse. The cultural backgrounds and the traditions can be very diverse. And so I think while you try to do what you plan to do, it's quite important to adapt language, your reasoning, your assumptions according to the tribunal you have for that day, to ensure that your arguments are understood, that they are persuasive to that particular tribunal. And some distinctions could be, the typical ones that you may see. Tribunals that are more inquisitorial in nature, they may be more inquisitive. They want to know. They will ask you very direct questions, or there could be tribunals who like emphasis on case precedents. Sometimes the common law background, tribunals from common law background may emphasize a bit more on case law precedents or authorities for certain arguments. And I think as a good advocate, you need to adapt to those kind of preferences. And the interesting thing about being in a moot is that every round you get a different set of tribunal, and every round you may be arguing the exact same case, but having to adapt it in various ways. And I think that's the beauty of the practice rounds, because you get to practice it before different tribunals and learn how to adapt your arguments accordingly. So that oral advocacy in arbitration is also very precious, I feel, because unlike in litigation where you get quite a lot of time to argue your cases, in arbitration and even in practice as well, most tribunals are very strict on time. So time management as an oral advocate is also quite important, because you want to make sure that all your most important points are hopefully presented before you run out of time, so that time management and the ability to pull the tribunal back to where you want them to go is important. But I would say that if you have to choose between finishing what you have to say and addressing the tribunal's concerns, in real life practice, I always try to address the tribunal's concerns. There's always the written advocacy that has dealt with your positions. Just finish, you could finish off with saying something like, that you stand by your submissions in the written advocacy and things like that. But I do think that in real life practice, especially, I try not to leave any nagging question hanging at the end of a hearing. I want those questions answered. And sometimes it's also important to be candid and honest, because if there is no answer, if I were the arbitrator, I would rather that you tell me that there is nothing in the facts that deal with that, or there's nothing, you have seen all the cases and you can't find a case, rather than giving an answer that could confuse things further. So I think those are the three things: the clarity of arguments, ability to respond to the tribunal and answer their questions that they want answered, and a sensitivity to the different cultures or legal traditions. I think those are the three things that I feel are probably, at least to me, most important in oral advocacy.
Okay, that's very interesting. And I really like your expression, read the arbitral tribunal, read the arbitrators. Do it before and do it during the hearing and be flexible. That's very important. That's, by the way, if I go to court in Germany, I always try to get a glimpse of what's going on and sit there half an hour before, so I know how the judges deal, and that's very interesting. So you mentioned that this is something for the moot court and something in real life. Coming back to real life and coming to the SIAC rules, we don't go into the moot problem here, but one issue here is the MET-ARP system. Is that something you do often in your experience? Is this something special for Singapore? Or is this a general development that you have first an escalation clause, for example, first mediation and then arbitration?
Sometimes we call it a multi-tier dispute resolution clause, or or preconditions to arbitration, has become very popular in Singapore as well as the region and internationally, I'm sure. We see a lot of mediation in the midst of whether arbitration or litigation in Singapore. If you talk about litigation in Singapore, it is now a requirement that you must make an offer to settle before you can commence, before you can even commence a suit. And in the middle of the suit, in fact, in the beginning of the suit, very early stages, the court will literally almost compel you to mediate. In arbitration, we see it a lot, but not so much in the form of the AMA protocol, not so much in the form of the AMA protocol actually being written into the contract. We see a lot of the tiered mediation clauses that requires you to mediate before you go to arbitration. And in fact, last year, I think I probably had more. I did more mediation advocacy than I did arbitration advocacy, because we had many matters that went into mediation, and with very good results. So it is definitely a trend. This having some kind of mediation as part of the arbitration process, but honestly, I have not seen as much of the SIAC, SIMC up protocol actually written in the contract that I've actually seen coming up to a dispute in practice. But it's obviously an option, and it's sometimes we actually consider it at the point when the dispute happens. Sometimes when a dispute has happened, even though it's not in the contract, I have opposing counsel coming to me and saying, like, do you think you want to consider, or your client wants to consider adopting or agreeing to the up protocol? I mean, I think there are some advantages and also some disadvantages to the protocol. One, if you write it in, I suppose in a way you streamline the process from the beginning. There is some cost savings. I think there's some certainty that mediation will happen in a certain way, and I think you sort of combine the efficiency of the arbitration in the SIAC as together with the mediation that's conducted by the SIMC. I'm not trying to do a plug for SIMC, but I'm quite a big fan. I think they do their job really well. They run the logistics really well, SIMC, and so I really quite enjoy my mediations at the SIMC. So I think in a way it sort of forces parties to adopt a certain protocol that is quite streamlined and efficient. But there are also some issues in practice for the up protocol. I think there's still some uncertainty as to what happens if in the midst of that stay, and in the midst of that stay you are supposed to be in mediation for 8 weeks. What if you need urgent interim relief during that mediation phase? What do you do in that situation? Do you stop the stay, go back? I mean, there are many options that we can consider, but there aren't any hard and fast rules currently about what happens in that kind of situation. And of course, you also have situations where the up protocol is not fully adapted or adopted into a contract, and then you get like a halfway house, and then there are also questions as to how do you deal with that. But I think by and large, there is definitely a trend towards having mediation as part of the dispute resolution process in arbitration, and is currently highly encouraged in all arbitrations. And I'm not sure tribunals would actively want to encourage parties to settle. I don't think I see that as a trend. Parties will generally still do it, but I don't see tribunals doing it the same way as the court does it. I've heard an interesting view about mediation being written into the dispute resolution clause. I had a client who told me that they have removed all mention of mediation from all their dispute resolution clauses in their contracts. So they choose arbitration, but they don't mention mediation at all. And I think that is an assessment. They said that that's an assessment of whether you think you are going to be the party suing or whether you're going to be the party being sued. Because if you are the party suing, they feel, and that's their assessment, that they are most likely to be the party suing. They don't see a reason to put in a mediation clause because that they see as a hurdle to them commencing arbitration. And to them, if parties have the intention to mediate or you want to settle, it is always open to you to mediate. So there's, in a way, they see it as there's no need to restrict yourself by having it written as a condition or as a requirement. And if you have seen some of the cases, and I've handled a few of those, there have been a lot of cases dealing with, whether there is jurisdiction if you didn't fulfill a certain precondition to arbitration, so to speak, that requires you to mediate in a certain way for a certain number of days, and with certain restrictions in place before you can commence arbitration. And that, in a way, has spawned off quite a lot of delays as well as arbitration cases before the courts that may or may not help with the efficiency of arbitration. So I think that is good and bad, but definitely there's a trend towards mediation.
Yeah, okay. That's very interesting. And the point you mentioned that you asked the parties about what may happen. Will you be sued or make it more difficult or make it easier? That's very important. I do the same whenever I'm asked to draft the dispute resolution clause. By the way, this is an open discussion, so any one of you who has a question, please feel free to speak up or write it in the chat. We're really open here. So go ahead. But let's turn a little bit to the SIAC rules. You did, when you explained that international, almost exclusively international mediation under the SIAC rules and the ICC rules. If you compare the rules on your experience, what's special about the SIAC rules? You mentioned the protocol, but is there anything other which makes your rules special?
I think that the SIC has always, I think the most important thing about arbitral institutions, both SIC and ICC, I think when people choose it, they choose a certain framework and a certain logistical support. So I think it's really the counsel in whether SIC, ICC, that sort of make a difference to how the cases are administered. But in terms of the rules, I think the recent SIAC rules, the 2025 rules, that set of rules have become quite a game changer in some ways, and I think particularly for young arbitration practitioners. There's this thing about the something that's probably more relevant to the question. I won't go into the question, but you will see that there is this third-party funding rules that has become quite advanced in the SIAC rules. It now requires certain further disclosures when you have a third-party funder. So that's one thing that the 2025 rules, SIAC rules, have introduced. But I think the most important introduction really is the streamlined procedure. The streamlined procedure under the SIAC rules is quite a game changer because it has differentiated itself from all the other rules by creating this procedure that is truly suited for much smaller disputes, which is why I mentioned earlier that this is likely to, at least for some cases, switch parties' preference for courts to arbitration. Because previously, for contracts where you think you probably are of much smaller value, you probably won't choose arbitration. You will just go to the courts because the Singapore courts are also very efficient, generally very efficient. But now with the streamlined procedure, which introduces just a 3-month procedure for all cases below $1 million, and this is Singapore dollars, which is a bit less than US dollars. Within 3 months, that's something that is, I think, quite attractive to many users. And I say this is good for young practitioners because, with cases like this in arbitration, it gives many younger practitioners, I think, the opportunities to sort of handle their own cases. Because when the arbitration cases of a bigger value, often the clients will request for more senior practitioners to handle the cases. But when you are dealing with an arbitration procedure that is only 1 million, in many cases, in most arbitration cases, it will be higher than that. But for cases that are 1 million Sing dollars or below, you suddenly have this 3-month very short procedure, which I think many clients, and I've seen it in practice, is given many of the younger practitioners in my team, an opportunity to sort of have much more say and much more involvement in handling these cases. So that really differentiates itself from the other rules, whether it's ICC, whether it's LCIA, or the Hong Kong arbitration rules, because most of the other rules have a 6-month procedure for different values. And the values are usually about 3 million, or more. So, but this one for 1 million or less, and it also has a by default no hearing. That's the default. There's no hearing. It's documents only, and so that gives. I think it's quite a different creature from the usual expedited procedure that you see. In combination with that is the introduction of the expedited procedure for values all the way up to 10 million. For many other rules, the threshold is much lower. So, for an $8 million case, for example, before the ICC, you will not have the expedited procedure. But now under the SIAC rules, even for an $8 million claim, for a $10 million claim, you can have an expedited procedure for 6 months that will finish in 6 months. So I think that is really the difference in the rules that is, I think, compared to the previous amendments, this set of amendments have gone much further, I think, than many people anticipated. Of course, for many of the people who are arbitrators, it is quite scary because 6 months is already is a very short period. And now suddenly you have to render a decision in 3 months. That's considered a very short time for you to finish the procedure and to render the award. So that's for many arbitrators during the consultation process. I know that many arbitrators express concern as to whether such short timelines can be adhered to. And I think the other thing that the SIC rules have also introduced is to take away uncertainty from the time of the end of proceedings to the time that the award needs to be rendered. Previously, it used to be 45 days from the close of proceedings, but then the tribunal gets to decide when the proceedings are closed, whereas now it's 90 days from the last submission or hearing. So it's much more certain now, those timelines that are important to users when the award will be out. I think that has become much more certain in the new rules. But other than that, I think all of us know that most of the internationally recognized rules will generally have most of the procedures and most of the tools that you need to make an arbitration efficient. But I think if you want me to, if I were to say a few things that the latest SIC rules are truly different, I think those will be the few that I would think will consider different, especially for arbitration practitioners and users.
It's interesting that you mentioned expedited. In our firm, we just finished an expedited procedure under ICC rules. And as you mentioned, you have 6 months from the first case management conference to the rendering of the award. But the ICC requests the arbitrator to have the award drafted 1 month before. So the time frame is very short. We have an interesting question in the chat from the Berlin Humboldt University in context with the AMA protocol. How prevalent are consent awards under the SIC rules? And are they only reached under this protocol, the AMA protocol, or also under other met-up proceedings, or maybe generally under other proceedings? So what about consent awards? And thanks for the question in the chat.
I do, in recent years, I have had many more of these consent awards. It does, as I say, I seldom see the AMA protocol in in the dispute. I haven't seen it that much in my practice, but I've seen quite a number of consent awards. I think we have, in a way, it's become quite a habit or a practice to have, if in the middle of arbitration we reach a settlement or we agree on how we are going to resolve the dispute, we will get the tribunal to record a consent award. I remember that when I first started practice, it was not that much of a practice. You will just settle and you terminate the arbitration and it ends. You may not have a consent award. You will just have a settlement agreement. What happens more often nowadays is that we have a consent award that records the main terms of the settlement agreement. It may not exhibit the whole of the settlement agreement. It depends on what is in the settlement agreement, but it will reflect the main terms of the settlement agreement, and we get the tribunal to record that in a consent award in preparation for the possibility that you may have to enforce it at some point in time. If there's any breach of the settlement agreement, so to speak, that you will have actually a consent award as opposed to just a settlement agreement, and then end up in a different dispute as to how you're going to enforce that. So I think in recent years I've seen it and tribunals are quite happy to do it. Tribunals are quite happy to for the parties to give them a template. They look at the template for the consent award. They may add certain things. They may want certain procedural things written into it, and then it doesn't have the reasoning, but it has a consent award in the main terms of the settlement agreement. So it is it has become quite common in recent years, at least from what I see.
Okay, very interesting. And that leads me to the last but one question. You mentioned enforcement. Is Singapore a favorable jurisdiction to enforce arbitral awards? You mentioned the New York Convention. And if this is so, and assume it is so, why and what do you recommend foreign parties coming to Singapore to make sure it's enforced?
We always say that Singapore is, people always say that Singapore is pro-arbitration. And it is true that Singapore is pro-arbitration in the sense that most people will see it as there are very few cases that will be set aside before the Singapore courts. Very few. By and large, cases are enforced. The awards are enforced, and setting aside are generally difficult. Setting aside of awards are generally very difficult. So enforcement of awards is mainly, I think, one of the main reasons, and I think that applies for all jurisdictions where enforcement is efficient, is when you have judges who are very familiar with the rules of enforcement and the regime around enforcement of awards. So in Singapore, we have dedicated judges who hear a lot of arbitration cases, and so the process of enforcement is quite straightforward in Singapore. One interesting thing is that while Singapore is pro-arbitration in the sense that very few cases will be set aside and most cases will be enforced without any hiccups, pro-arbitration in the Singapore context also means, and the judges are always reminding us of that, it also means that if there are cases where we have an award that truly offends the basic principles of arbitration, then it is the duty of the court not to enforce it or to have to set it aside. And that should not be seen as not being pro-arbitration. That is also pro-arbitration because you are enforcing the nature and the basis and the fundamental rules of arbitration. So in cases where you have truly, there's no, the jurisdiction of the tribunal is in question, or certain procedural fairness has not been accorded, or the award is truly, not reflective of good arbitration practice, in those cases, we have seen the court, exercising their discretion and exercising their powers to set aside those awards. And I think famously recently, it made quite a bit of international news when an award that had 200 over paragraphs out of 400 over paragraphs copied from other awards. That award was set aside because there were three linked arbitrations resulting in three different awards. But this particular Singapore-seated arbitration had 200 over paragraphs copied from other awards, from the other two awards. That was wrong, and that award was set aside. It was quite big news. And I think in Singapore, when there are cases like this, which are fundamentally against the rules of arbitration, the courts will, exercise their powers to set aside those awards. But by and large, awards are enforced quite easily and very smoothly and quickly. The other interesting thing is, if you look at the statistics, and I like to look at statistics, if you look at the statistics, there are only about 23% of settings aside applications are successful in Singapore. And I don't know whether people see it as low or high when you see 23% successful setting aside, but and I have friends in the arbitration circle who are doing research on this, because actually when you see 23%, that's actually 23% of the reported cases, because often you have many of these judgments, many of these cases where people try to set aside, and on the spot, that means like right at the end of the hearing, it gets dismissed. So the setting aside is unsuccessful, and there are actually no written grounds. There is no decision. There's no judgment, and so there are many of those cases where enforcement is successful or setting aside is unsuccessful. That's actually not reported, and that is something that you don't get to see in the cases and the decisions that are in your law reports. The ones that you see in the law reports give you a figure of about 23%. And I think I have friends who are doing research to show that actually the figures are much lower. The successful setting asides are actually much, much lower than 23%.
I would say 23% is quite high.
Yeah, I would say that it's quite high too.
Yeah,
I would say that it's quite high. But I think, the reason is because most setting asides, which are unsuccessful, will just not result in a decision. is not reported. You got to trawl through the court records to find those cases, and there are many of those cases because we have had many cases where we have had to defend an award, and at the end of the hearing, the judge will just decide that there's no basis to set aside, and he or she will just dismiss the case, and then there's no report, there's no judgment, there's no decision, and those don't end up in the statistics. So actually, the actual statistics are much lower than 23%.
That sounds very good. We're almost at the end, 3 more minutes, and we try to be punctually. You praised Singapore too much. It's really interesting, and those people who have seen pictures from that. So, to our students, if they're interested to an internship, a clerkship, or even employment, is this possible in Singapore?
We have had there are actually quite a number of foreign law firms in Singapore from civil law jurisdictions. I did a check, and apparently out of the foreign law firms in Singapore, there are about 20 to 30%, which are civil law firms from civil law jurisdictions. They may have small offices, but they do have practices here. And I think there is quite a community of international arbitration practitioners in Singapore that are from a variety of backgrounds. So I have many friends. They are Swiss, they are German, they are French lawyers, but they practice in Singapore. And I think from that you can tell that there will always be opportunities for that. Usually the hurdle is not whether the law firm in Singapore can have you. It's more an immigration hurdle that people have to cross to get into Singapore to do the internships, because you need to be, I think you need to, it's not that difficult, but it's just a process that you need to go and get a certain work pass from the immigration office in order to be able to do an internship in Singapore. So I think that is the more of the issue rather than a place in a law firm. I think in Singapore, it is so diverse that I think it is definitely possible. And I should also mention that while I work in Singapore and I've been entire professional life in Singapore, I'm actually Malaysian. I'm not Singaporean. I'm not Singaporean, and I am Malaysian, even though we are very close by. It's just a drive away.
So you prove that it works, and it's probably easier to get in than into many other countries. Well,
Yeah.
Thank you so much. That was very entertaining. We could talk for ages, and I hope we have another chance. Either you come to Germany or I come to Singapore, and all the other people. Thank you very much for your time. Thank you for the participation. Thank you for at least one question. And we're all looking forward to seeing you in the exciting next 2 weeks at our BODENHEIMER Pre-Moot, the 6th Pre-Moot. Again, thank you very much, Min, and looking forward to seeing you all very soon.
It's been a real pleasure. Thank you.
Thank you very much. Bye-bye.